Welcome back to the second part of this law session on contract. And before the break, we were exploring illegal contracts, and I said to you that immediately after the break, we would continue by looking at restraint of trade clauses, and also we will look at minors and capacity to contract. Well, let's start off with restraint of trade contracts. Now, you will be able to identify these generally because this is usually contracts where you have somebody with a special skill or someone who is in a situation where, for example, they're working in a company that has very specialized systems or trade secrets or intellectual property. And so what you don't want is for the person to leave and then he goes and works for the competition, for example. So contracts in restraint of trade is of that genre of contract. Now, where you have a contract in restraint of trade, it is a situation where you're seeking to restrict a person's freedom to carry on his trade or his profession. Now, they are valid, but only if they are reasonable as between the parties and from the point of view of the public, of course. Now, the standard for restraint of trade is clearly set out and can be clearly seen in two cases. There's the Herbert Morris and Saxelby case in 1916, and the Mason and Provident Clothing and Supply Company Limited case in 1913. Now, what it says is that you have to look at whether the restraint is reasonable as between the parties. It must do no more than is reasonably necessary for the protection of the employer. Now, the clause must protect some legitimate interest of the employer, and the employee must be free to exercise his general trade, as it were. Now, when you consider restraints on employees, as I say, these are valid, but it must be that there is a valid proprietary interest or a trade secret or something like that. And the restraint is no wider in terms of time and area than is really necessary to protect the proprietary interest of the employer. What I mean by that is that if you start drafting a contract which says, if you leave us, and let's say we are a telephone mobile company, if you leave us, you can't work for anybody in the entire England and Wales, the courts may not look too kindly on that. So when you look at the time and also the area, the geographical area, that has a bearing. Now, the standard for the restraint of trade, as I said, is set out in these two cases here, and the requirements as well is what the three requirements is as we've looked at. Now, in Herbert Morris, the respondent was employed by the appellant as a draftsman in their business of manufacturing lifting machinery. Now, the company had its head office in Loughborough, and they had branches in 8 large cities. The contract of employment contained a clause that for 7 years after leaving, he would not become engaged anywhere in the UK in any similar business. Now, this case went eventually to the House of Lords, and the court said the clause was wider than reasonably necessary to protect the employer's interest. The appellants, the court said, the employers were merely trying to reduce competition, and that, unfortunately, will not be sufficient. The courts looked at it and said that no person has an abstract right to be protected against competition per se in his trade or business. The only reason for upholding a restraint of trade clause on an employee is that the employer has a proprietary right, and that proprietary right or interest may be affected. Now, in Mason and Provident Clothing and Supply Company, this looked at the restraint and the area of application. Now, This was a clothing and supply company which had branches all over England, and it employed Mason as a canvasser in a particular district of London. Now, a contract by Mason not to be engaged in any similar business within 25 miles of London for 3 years was held by the House of Lords to be void. Now, the courts arrived at this decision by looking at the evidence in relation to the character of the business, and they also looked at Mason's duties as a canvasser. The court said that there was nothing from which it could infer that a canvasser could be possessed of any kind of special knowledge and skill of the type that this particular principle envisaged. And so, of course, the court said that it wouldn't uphold it. Now, for something in respect of public interest, an interesting case in that regard is Wyatt and Kreglinga and Inferno, which is a 1933 case where an employee who was a wool worker was promised a pension on his retirement, and it was agreed that he would not receive the pension if he competed against his employer in the wool trade. Now, the Court of Appeal said that that type of transaction would be void. It said it was contrary to the public interest to deprive the community of a valuable skill, and certainly a valuable skilled person as the employee was. Now, public interest is almost impossible to define, but it is unlikely that a particular restraint will be struck down simply because some broad-based economic interest will be affected. What about restraints on the vendor of a business? So I am selling you my hairdressing business or my cooking business. What happens if I sell you the business, but then the day after I sell it to you, I decide to go and open up a similar business? Well, the restraint, when you're looking at clauses to do with such types of restraint, the restraint is reasonable if it protects only the business that has changed hands. The vendor is not entitled to protect any other business he may own. And the classic case, of course, on this is Nordenfeld and Maxim case in 1894. Now, in the case, we see that when a business is sold, the purchaser, of course, is very wise to insist on a restraint of trade clause to prevent the vendor from then starting a new business and drawing away clientele from the established business. Now, the purchaser will often have bought the goodwill and the custom of the business, and then this is, of course, something that the courts will look to protect as it relates to a restraint of trade clause. Now, courts are much more likely to uphold a restraint of trade clause found in a contract for the sale of the business than in a contract of employment. Now, the criteria for determining whether or not a restraint of trade clause in a contract for the sale of a business is enforceable, the party seeking to enforce the clause must show that the clause is reasonable in the interest of the parties to the contract. Now, in determining the reasonableness, the courts will have regard to the consideration which has been paid for the business, and the clause must be reasonable in light of the interest of both parties. Now, there is a rule from the Nordenfeld case itself. The general rule is that all interference with individual liberty of action in trading and all restraints of trade themselves, if there is nothing more, are contrary to public policy and therefore void. It is a general rule. It means, of course, that there are exceptions. So if it is justified because it is reasonable having regard to the interests of the parties and the public, then you can have something like that being upheld. Now, the House of Lords believe that a covenant not to compete in any future business undertaken by the business in the Nordenfeld case said was unreasonable because it sought to protect the future activities of the business. The House of Lords did, however, find that a worldwide restriction was reasonable because of the limited numbers of manufacturers in this area, and that would obviously assist the party seeking to rely on it. Now, the next point to, of course, consider is, what about exclusive dealings and exclusive service agreements? Well, exclusive dealing agreements, these are contracts where one party undertakes to purchase all of its supplies from a certain supplier. And the classic case is Esso Petroleum and Harper, and this is a 1968 case. The courts will hold that these agreements are unreasonable only if they contain unusual or novel features, or there is an unbalance or imbalance in respect of the bargaining powers of the parties, or the agreement is likely to cause hardship to the weaker party. Now, in the Esso and Harper case, Harper had agreed to buy its petrol exclusively from Esso for a period of 4 years. Now, 5 months into the relationship, we see that there was a problem between the parties. Now, you look at whether this is called a Solas Agreement. You look at whether the Solas Agreement is such that it would cause a hardship. If it is for example, a short period of time, and in this it was for 4 years, 5 months, versus, say, 21 years, which was another Solas Agreement. Well, in relation to the short Solas Agreement of 4 years and 5 months, the courts didn't have a problem with it. But in relation to the second Solas Agreement, the court said the promise was given in connection with the loan from Esso for him to have this business. And the courts considered that as it relates to the 21 years, it went beyond what was required to protect the interests of Esso. Another interesting case is the Schroeder Music Publishing and Macaulay case, where a young songwriter had contracted with music publishers to provide his exclusive service for 5 years. Now, during that period, the songwriter assigned copyright in his music to the publishers. The music publishers were under no obligation to do anything with his songs. In the event that the songwriter's royalties exceeded a certain amount, the contract would be automatically extended for a further 5-year period. Now, while the music publishers were able to terminate the contract, the songwriter did not have that right. The House of Lords applied the decision in Esso and Harper and found that the case was an unenforceable restraint of trade because it went well beyond what was necessary to protect the industry, or rather to protect the interests of the music publishers in the industry, and so severely curtailed the songwriter's ability. Now, it is going to be difficult at times to sever, but in the same way we looked at severability of illegality, severability of a contract in respect of illegality, let's consider severability of void restraints. The court may sever a part of a contract where part of it is that the restraint goes beyond what is required at law. Now, it may therefore leave the enforceable part of the contract intact. The objectionable part of the restraint only, provided the severance satisfied what is called the blue pencil test and does not alter the nature of the restraint, the court may very well leave it in. Because you may try to sever, but taking out the restraint clause may mean that the contract has no business efficacy whatsoever, in which case it is of no value. So it must still be able to stand by itself. Now, we will go into a short break, and when we come back, we will start considering cases in relation to minors. When can you make a contract with a minor, and how can you seek to ensure that contractual liability lie against a minor?